I have to hit record. Okay. All right, so pursuant, I'm calling the meeting to order. Thank you. May 6th, Adams Board of Health meeting. Pursuant to Governor Baker's March 12th, 2020 order suspending certain provisions of open meeting law and the Governor's March 15th, 2020 order imposing strict limitations on the number of people that may gather in one place, this meeting on the Adams Board of Health is being conducted via remote participation. No in-person attendance of members of the public will be permitted, but every effort will be made to ensure that the public can adequately access the proceedings as provided for in the order. Attending remotely are members Dr. David Rhodes, Dr. Laura Grandchamp, with myself, Dr. Peter Hoyt, attending from Town Hall as Chair of the Board of Health. We have posted today's agenda, which included the call-in information for today's meeting. Despite our best efforts, we are not able to provide, if we are not able to provide for real-time access for the public to participate in today's meeting, a recording of this meeting will be made available. As we are participating remotely, please note that all votes taken during this meeting will be by a roll call vote. I will state the Board of Health member's name and ask for their vote for each vote necessary today. Okay.
And just to emphasize that the meeting is being recorded.
Yes, the meeting is being recorded. Yep. Okay, so hopefully we will get through this without any technical difficulties. I'm going to try my best here. We'll see how this goes. All right, first thing on the agenda is the approval of the March 4th minutes. So I know those were sent to all of us ahead of time. Any discussion, any changes on that?
How can the public see those?
They will be made available when they're approved.
So, to confess, I did not have a chance to read them because I was reading other materials. Is there a chance we could postpone? Or this was a meeting that you missed, Pete?
Yes, yeah, I would have to abstain from voting. Okay, I'm hearing some background noise, so I'm muting everybody except for the board members. Hopefully that's working.
Unless it's the board member has some background noise.
Yeah, I mean, what do you guys want to do? I'm abstaining from the vote and the discussion because I wasn't there, so.
I did read them. I did not have any changes to add to it, but that's only one person, so.
I would be willing to go with that because you were there and Pam was there. So I will make a motion to accept the minutes as presented.
Second.
Okay. Any further discussion on that?
No.
Okay. So this, again, a roll call vote. Laura?
Yes.
David?
Yes.
Okay. And me, I'm abstaining, so minutes are approved. All right, good. Okay, next up is our first public hearing, and this is 10C Murray Ave. Kathy Foster. So we have Mark here. So how this is going to work, from my understanding, is we're going to have Mark present his side and his findings, and then we'll have Ms. Foster. You'll have a chance to speak on that, and then the board will discuss that, and we'll make our decision. Okay, Mark, you have the floor.
Okay. So on February 24th, I issued a no occupancy order upon this apartment 10 Murray Street, Unit C, based on a pre-tenancy inspection that was performed on February 12th. The reason why I advanced it to an actual order was because Ms. Foster missed her 7-day deadline to file an appeal on the pre-tenancy inspection, so I put it to an order to give her an opportunity to file an appeal before the board. Excuse me. So within the no occupancy order, I cited as the reason for the no occupancy order was there's no secondary exit in the apartment. I also cited 2 other conditions. One, that the apartment was, all the apartments were not addressed with the unit numbers, and there was no electrical outlet in the bathroom. Further in the notice of the pre-tenancy inspection, I commented upon potential lead paint hazards being present, and her requirement also to make notification of lead paint hazards in the apartment to prospective tenants as well as to the occupying tenant. So Ms. Foster challenged the order. Since the last hearing, I have obtained a copy of a court order out of Western Mass Housing Court that emphasized that the apartment does in fact need a secondary exit, being a door, not by means of a window. So I guess I'll turn it over to Ms. Foster.
Okay, I'm going to unmute. Okay, Ms. Foster, I've unmuted you, so you have a chance to speak now.
So I'm not prepared for this hearing. I've reached out to Mark twice and asked him questions about this. He refused to answer me on either of them. I need to know why we're starting over again. What happened to the hearing I had on March 4th?
Okay, I was not in attendance in that meeting. My understanding that it was continued until our next meeting, and that meeting was canceled because of the emergency order and the whole COVID-19 issue, and this is our first chance to meet. So that's my understanding of it. That's why we're doing this today.
The meeting it was supposed to
may I-
be continued to was March 11th, and things weren't closed down until the 17th. On the 11th, we worked it out at the hearing on the 4th that we would go back in a week, understanding that we weren't going to use the same room and that the room we were going to use might be cold. The next day, I got an email from Mark saying that there was a conflict because that room wasn't available, and that he would let me know when it was available.
Yeah, may I?
Yeah.
My understanding was not a conflict about the room, but that Mark Blaisdell and Jerry Garner had to attend a budget meeting with the select board. My memory might be sketchy on this, but yes, I was a bit frustrated myself that this was added, noted after we had decided on March 11th, which, you know, we worked hard to get that date. As for what we were thinking you would be doing in the interim was actually going to the state to find out what, if you could get a waiver because Mark Blaisdell continued to say that we were not the appropriate forum for appeal, that it's a state mandate, and therefore, if there's any waiver, it would have to go through the State Department of Housing or whatever, I'm not
Yes.
sure.
Mark sent me a link, and that link that Mark sent me to was irrelevant. It was for something that you needed to have an account to log in. It didn't work at all. I sent an email to Jay. I told him that. I also sent Jay a position letter from the Mass State Department of Public Health, which indicated that I did
Objection.
not.
Objection. Objection.
Okay.
Can you please mute him? I was muted while he talked.
Oh, go ahead.
So
Go ahead, Kathy.
the letter that I sent him said that they believe that I didn't necessarily need to have a second door, that it was, of course, up to the circumstances,
Again,
but
objection.
it included, are we adults here? I mean, really? The position letter said that it also included,
Objection, hearsay.
all right,
You had an
I
opportunity
obviously
to submit
can't,
those
I
documents
can't talk
before
under
this
these
hearing.
circumstances.
Okay. I'm trying to understand what she's saying though, Mark.
Okay, that's the purpose of the objection. You have to rule on the objection.
Okay. But I can't hear what she's saying, so what is she, what are you objecting?
She had an opportunity to provide whatever documents she obtained, as she's saying she has obtained. It's not proper for her to say that so-and-so has said this, so-and-so has said that, without providing that documentation or that person as a witness.
Right. Yeah, I kind of agree that I didn't see any documents stating that you could not get a hold of this,
You didn't see documents because Mark didn't answer my email about this. Mark didn't provide any documents to me. As far as I'm concerned, without an exchange of documents, this is a non-meeting. I don't have anything that Mark is planning to bring forward. He didn't send me any documents.
my understanding is that you got all the information.
What's that?
My understanding is that you did get all the information.
I don't know. Why is he asking for more information from me? He wants all of my information. And he wants me to provide it to him in 24 hours notice in a single PDF file, exhibits numbered within this single PDF file. But we're still back to the point of why are we starting over at the beginning? Because it was my understanding after the meeting on the 4th that we were going back on the 7th for decision after the board was going to meet with town council. And I know that as of the 11th, they hadn't met with town council.
Yeah, just from my end, again, I was not at that meeting. And again, being the chair of this board, I was not aware of any meeting on the 11th, or any discussion with town council about this. So, Jerry?
Point of order. Jerry Gardner, I don't know if you can hear me. Can you hear me?
Yes.
Okay. We cannot use town council for a private resource for the general public. Town council is only utilized for the town government. We're not using town council to discuss issues of private citizens within the municipality.
Isn't the Board of Health town government?
Board of Health may discuss it. They cannot use town council to discuss personal issues. If you're asking town council questions, he's not going to answer you. If the Board of Health is asking him questions, he will answer them.
Well, let me
I
repeat
think that
myself.
was,
We were
excuse me,
supposed to meet
Kathy.
back a week later after the Board of Health contacted town council.
Kathy,
Yes.
may I interrupt? I'm sorry. Yeah, I did drop the ball on this because, in part because of the meeting being actually canceled. But my understanding is that we would be asking town council regarding our authority as a Board of Health to waive or postpone compliance of this housing code issue. And so It's not a personal, we would not be going there on behalf of you, but we would be going to town council regarding what can we as a board, what are we allowed to do? And we would make a decision based, obviously on safety, but we could not make a decision that went against a state or local code.
Well, I think there was more to it too, because I think that I was saying the code said one thing and Mark was saying those same codes said something different. And Mark was also saying that different codes applied. And I think you were going to check on that, on get a clarification on which codes we were even looking at.
Okay, I can clarify.
Go ahead, Jerry.
One of the deals is that under the Board of Health regulations, the sanitary housing code, you have a reference that goes to the state building code. So the reference, it gives Mark the authority to address the issue of a secondary means of egress, but that automatically goes to the state building code. Now, the letter that was written by Mr. Hughes is incorrectly stated, and it's not correct at all.
Who's Mr. Hughes?
Oh, I'm sorry, Paul Hoffman. So Paul Hoffman has misstated the building code. I checked with the state, after I heard about this, I checked with the state inspector. He went to the Board of Health and he talked with Mr. Hoffman. Mr. Hoffman has recognized that he's incorrectly stated this in the letter. It's incorrect information, and you do need a second means of egress. The state building inspector was supposed to get back to me by today, which he did not because he's held up in this COVID thing. But he does have a letter that he's writing explaining what the problems are with what's going on here in the state sanitary code, and what this gentleman's determining what a means of egress is. This is the incorrect determination of a means of egress, and it's not applied that way in the building code.
Objection,
Yeah,
hearsay.
Well, no, I don't think you can object, but I can. Did I miss these documents?
I sent them to Jay, the only person I knew to send them to.
No, after Ms. Foster contacted Mr. Halfman, Mr. Halfman then contacted me, and then I made a Freedom of Information request for all the communications between him and Ms. Foster. So I have all the communications between him and Ms. Foster as well as the court order.
That court order was the East Longmeadow thing?
Yes.
Okay, yeah, it's just a relevant case. Okay. May I try to break through this a little bit, because obviously there's a lot of missing stuff, and we go back to what we did last time and say, meeting this way is challenging, but it's possible. Can we meet next week and we go through all of the documentation we need?
Yes. I also need to get all the documentation this time that Mark intends to use, rather than having it brought up at the hearing like it was last time. Because the last time he had a lot of things that I had no access to.
So-
You were given the documents as they were presented to the board.
Right, but I wasn't given them in advance as I was entitled to, and as I'm asking to be this
But
time.
you never made that request. The
All right, Mark,
documents
I'm
were
not gonna
presented
play
to
word
you
games
as they
with
were
you. I'm
presented
telling you
to
right
the board.
now,
Okay, can we just go
I
back?
want the documents
and-
before the meeting
and-
next week.
If we can set a date certain, like
But
next week?
I still need to know though, like, that whole hearing we had last time, that's just for nothing?
No, it's a process. And I apologize for what appears to be a delay, but we do want to get this right. Not only for the board, but for you, your tenant, and how we conduct things. And so this is painful for me too. Please bear with. If we could agree to meet sometime next week, this way, we would have time to announce the hearing. It would be the only item. And we, at this point, I think we should make a list of everything that should be brought to that meeting.
Okay,
Can we do that?
yes.
And I mean, yeah, Pete, can we do
I have a
that?
question for Ms. Foster. So it's my understanding that you were asked to ask for a variance through the Board of Building and Regulations and Standards,
Building Code Appeals Board.
Building Code Appeals Board, sorry. And
Hold on,
this
I'll tell
would be, this would correct your issue if you were granted that variance. Did you do that?
No, he didn't. He told me different ways to do that. At the hearing, he told me one place, and I called and they didn't know what I was talking about. They had no idea. That's how I ended up with Mr. Halfman, because I was bounced around until I ended up with him, and they said he was definitely the person I needed to talk to. Mark ended up sending me a link, and the link was it was useless. It took me to a place for contractors, but you had to have a subscription to get into there, to use it at all.
Okay. Is this, are you?
And I did tell Jay that.
But she never communicated back to me.
Okay.
I communicated with Jay.
Yeah, so I guess if the information or the link was bad, it probably would have been in your best interest to follow back up and ask for the correct link.
Well, since we're talking about that, I don't really think it's appropriate in any way at all for Mark to be the one communicating with me about this, because Mark would be what I would consider to be the plaintiff in this case, and where Mark had a fit when I tried to get an answer from the Board of Health for going outside, yet he's communicating with you because he knows when the meeting is. And he's telling me when the meeting is. Shouldn't the Board of Health be communicating with me about when the meeting is, what I have to provide?
Yeah,
No,
yes, you are right. Yeah.
It is appropriate for Mark to do that. That's his job.
I suspect if the Board of Health sent me a link, it would probably be the correct link.
Let me check that out and send it to you. I know last time Mark said I could not communicate with you, but I'm going to overrule Mark in this case because I feel it's important that you get the correct link, that we make sure we're on the same page with, and I mean, I'm just looking it up on my phone here.
You can copy Mark on whatever information you give me.
Oh yeah, absolutely. But the last time I said I would communicate with you, and Mark said, absolutely, I could not communicate with you. And now I am saying I can, I will.
Actually, town council said you can.
He said what?
He said you
Objection,
can't.
hearsay. Objection, objection.
He said what?
He
What did
said you
Ed say?
cannot.
Okay, he didn't say anything to me. So at this point, I'm going to do what I think is best. This is,
I'll make the
this
complaint to
is,
the Attorney General's office.
so be it.
Okay, so,
All I need you to communicate with me with is what I need to provide, when, how, and our meeting. But if we settle the meeting now, you don't even have to send me an email about that because I'll have it written down.
I'm saying May 13, same time, same bat station.
May 13th, 4 p.m. Works for me. I will send all of my documents to Mark, and I would like Mark to do the same.
Hold on. You have to remember, we have budget hearings next week. I don't know if we're going to be able to, hold on a second.
We can't hear what you're saying. It's
we're
important that
checking
we,
the calendar because there's budget meetings, there's a lot of stuff going on here in town hall.
I can do Tuesday, Thursday.
My husband's looking up the dates for the budget meetings.
I think we're all trying to get on there now.
All right, May 6th, 7th, 13th, and 14th. So the 13th is at 5:30.
So we would be able to have a meeting between 4 and 5.
Works for me.
Do we need a vote on this?
Yes?
Yes, we do, but I don't know if that's really gonna work, that day and time. Is that 5:30, is that kind of, if we do this at 4?
We have to remember, we have to
Set up
set up everything.
That's what I'm worried about, it's gonna be
That's
kind
gonna
of
be really
close.
tight.
Because we have to sanitize the whole room and set it up again.
Can we meet earlier? How about 3?
3 works for me.
I can't do earlier.
Seven works for me.
I think it's gonna work either.
What about Tuesday, the 12th?
Yeah, the Tuesday, the 12th, I'm thinking that there doesn't seem to be anything on that day.
Yeah, I mean, not on the town calendar anyway.
Right, just, and, Laura, I know you've got some schedule things as well.
My schedule is reasonably open at this point.
Okay.
Tuesday does work for me. If the room, I guess the big thing would be if the room, is the room free? And is
If
there
you wanna
time to
wait-
sanitize?
If it's
Yeah,
easier to wait until after budget, we can do 2 weeks if you want.
Like the 20th, I didn't see anything on the town calendar on the 20th.
That can work for me.
Mark, 20th, work for you?
I can't get into my calendar.
Okay.
What day of the week is the 20th?
The 20th
It's
is
a
a
Wednesday.
Wednesday.
It's Wednesday. That works for me.
4 p.m.
Right.
Just, I'm waiting on Mark. He's looking at his calendar.
Yeah, I want to make sure that there aren't any budget meetings or anything else that will come up. I mean, we need to hold this sacred because it wasn't last time.
The 20th, we changed to the 20th now. Sorry about that. Works, 4 o'clock.
4 o'clock?
Okay. Okay, so, March 20th, or excuse me, May 20th, 4 o'clock, it's a Wednesday. So this would be a continuance.
Well, will it be a continuance? Is that what we're doing? Because you weren't there even the first time. Are we going to start from the beginning, or are we actually going to continue a 2-month-old meeting missing one member?
We can start over.
We could start over.
Yeah.
And then this way, you can get the information that you request. You can possibly get, hopefully ask for the link for that website so you can ask for a variance. I think that would be in your best interest as well, to ask for that as recommended.
Okay.
And we'll go from there. So, Laura, May 20th, 4 o'clock, that works for you?
Yes, that's fine.
And I got it on my calendar already. Thank you.
Okay, that works for me, so, okay.
Okay.
All right, thank you, Kathy.
I apologize for the delay, but may it be short this time.
Thank you.
Okay, so, next on the agenda is, hearing for, 40 Richmond Lane, Unit 1. And this is, Stacy Healy. And my understanding is Stacy couldn't make the meeting today because of, work issues. She also mentioned that, the notification was a little bit, it wasn't timely enough for her, even though I looked at the regulations, we have to give her 5 days, and we did give her 5 days, my understanding. But she's a healthcare worker, hard to find some replacement in a job, so that's something to consider with this. So the other thing is, because she's not present, because she's working, she asked if her husband could represent her. It's our feeling that can't be. I did look at the rules, and it was a little vague. It said an attorney or somebody appointed in that manner. So, I guess we, you know, Mark has his chance here to present the case, but we also have a decision here is, one is, do we allow, Stacy's husband, Mr. Healy, to present on her behalf, or again, do we just continue this until the May 20th, giving her ample time to, you know, take work off and be here at the meeting? So, I guess we could probably make that decision first before Mark presents. So David and Laura, what do you think with that?
I'd be fine if they were. It seemed like there were some issues that could be addressed between now and then.
Yeah, I guess the other question is there immediate threat to safety of the tenant? And, you know, if that's the case, then this is all, you know, we should talk about it tonight.
Correct. The tenant is not here, right?
Tenant is,
Tenant's attorney here.
Oh, wait, that's
Matt Mosian.
And
Matt,
that,
you are the attorney, right?
Yep. Hi, guys.
Okay. is here, and the tenant is here. I've unmuted you, Daniel.
Hello, everybody.
Oh, hi. So we've seen some of the communications, I guess, and as Chairman Hoyt pointed out, the urgent question here is immediate safety. And so if either of you could speak to that.
Oh, Jesus.
Well, I'm gonna say something that there was an email in there from the tenant, stating that the residence wasn't, being properly sanitized, and that bothers me a little bit.
That's not true.
So I'm worried about that a little bit, and Mr. Healy, you disagree with that, so, that's the thing that concerns me right now. I didn't really see, anything else of immediate, safety. Mark, did you have anything to add to that?
Mark?
So I guess our question is, what do we want to do? Do we want to hear this? Do we want to continue till the date of the 20th when Ms. Healy can be here? What do you guys want to do? David and Laura.
Don't know. I like this.
It appeared to me on the second inspection form that the immediate dangers had been taken care of. And so I don't see any reason why we couldn't continue it.
And I would just add, I would add to that,
I'm in the fire.
continued documentation of the, if any contractors come in, that they are properly outfitted with protective gear, and that the sanitation subsequent is adequate.
Which has been the case.
Okay. So is our feeling that we stick this on to the May 20? Is that suitable for all parties plus?
Yes, we would just have to, that one would have to be at 4:30. So if we do the Murray Street or Murray Ave first, I believe, that would take a half hour or so, and then that would give time for Ms. Healy to be here at 4:30.
The last one, I think that went an hour and a half.
Okay, so there would be plenty of time. Yeah. So we can keep the meeting at 4. We would just the Richmond Lane, we would discuss that second, I guess.
I think what he was saying was my hearing the last time took an hour and a half, that it's probably not going to only take a half hour this time.
Well, we hope we will have those ducks in a row for both sides. So yes.
Yeah, I think we'll be within a good time frame, I think.
So I do have a question.
Yeah.
I'm unfamiliar with the regulation you're talking about saying 5 days notice.
Yeah, it was, chapter 111, 127B, I believe.
That's condemnation.
It was,
That's condemnation. That doesn't pertain to this type of correction order.
right. That's correct.
So this hearing should take place today. She was given notice, and I'm prepared to go. And I think the tenant and his attorney are ready.
Okay. So Mark disagrees that what I saw online was for a different type of appeal, saying that the 5 days was for something else. And he's recommending that we hear the appeal now.
Matt? Matt, are you there?
And
Yeah, I'm here. I don't see you, Mark. Are you off camera?
I am.
he's off camera.
Okay.
He's right here.
All right.
Hi, Mark.
127B.
I believe that's what it was. I can't remember.
Is your recollection that being condemnation require a 5-day notice?
Mark, I don't know. I just figured I was going to jump on this call and hear what the actual issues
Okay.
were. I'm a little confused that there's even an appeal, given that the basis, what you put in your order.
Right.
But it almost seems like the owner's not present. Is that the scoop?
That's
Yeah.
correct.
Oh.
So I think that's part of the issue now is that since the owner can't be present because of work, do we hear this or do we wait until our next meeting on the 20th?
Well, I think my client and I are here. My client's probably prepared to testify if there are questions for him. But it seems to me that there's not even a way to really get this matter continued to another date because the appellant's not even joining us.
Well, she had requested the hearing. She was given notice, and for the record, 127B is condemnations. She was given adequate notice, a week's notice. I feel that she's had sufficient time to notify her employer to request the time off. So again, I'm prepared and tenant is prepared. I think we should either dismiss her appeal or present without her present.
So yeah, I mean, 5 days or not, she was presented the information within the 5 days. I originally thought that it was 10 from a quick search, and that was wrong. So, so again, is Mr. Healy allowed to speak on her behalf, for one? And you know,
Typically, he would not be able to, nor her mother. She would be represented by counsel in her absence.
Can I put my 2 cents in worth as a townsperson who's in a similar position? Given that this is the first meeting in 2 months and that everything was closed for such an, uncertain period of time, and then
That's fine.
suddenly get an email that there's a hearing, I really think you should, for the benefit of the doubt, you really want a decision that's based on the facts, not based on somebody not being able to make it.
Shouldn't be.
okay, thank you, Kathy, for that input.
So I'll present the facts.
1 second, Mark.
Okay.
So Laura, David, what are your thoughts?
Well, I think I'm a little lost in the weeds here. I think we're talking about a Mark Blaisdell order for the landlord to do stuff. And the tenant complaining that stuff isn't getting done in a timely fashion or in a sufficiently healthy way. And so the bottom line is the landlord's appeal that she is being treated unfairly in some way or other. Is that my understanding?
No,
I mean-
we just have an issue with two of the orders, the documentation that was sent in Blaisdell's order. There's one thing in there where it says we haven't had a pre-inspection before the tenant moved in, but we actually have a certificate of occupancy within the past 5 years.
That was Tom Romaniak who signed that one?
Yes, the
Okay.
previous inspector.
Correct, yes, okay.
And then the other thing was, Mr. Blaisdell asserted that we had not notified the tenant or given the tenant lead information, which is untrue. We have. So those are just the two things we have. We are complying with all the orders to fix, and we have been going through the process of fixing, you know, the issues. And we have been sanitizing the common areas every day. So, you know, those are the issues that we have appealed on, just those two things. And it's, you know, the
Okay.
documentation
I'm gonna
sent
interrupt you for a
shows.
second. Thank you, Mr. Healy. I'm gonna interrupt you for a second.
So if we're gonna hear the hearing, let's.
Right, I know.
So let's proceed, okay?
So I guess my question to the board is, are we gonna hear this or aren't we? Because we're kind of starting to hear it, which, you know, so I'm putting this forward is the, Miss Healy has kind of asked that her husband represent her, if we're allowing that, or do we just continue this until the 20th?
Let's proceed. To David and Laura?
So yeah, to David and Laura, I'm just.
It sounds
if I'm
like
hearing
we're
none,
not,
We're gonna continue. Go ahead, Laura, I'm sorry.
do we have the authority to allow him to represent her? If,
That I'm not sure. Jerry, go ahead.
Is she the only one is she the only one that's a tenant? Is she the owner, right?
Yes.
Is he on that lease or mortgage?
Mr. Healy, are you on the lease or the mortgage?
Oh, you know what? My wife actually just walked in, so we can just do this right
Here.
now.
Okay.
Beautiful.
Okay, so that solves our issue. I guess we're gonna hear the hearing then. Thank you. Okay, Mark, you have the floor.
Sure she's here?
Yep, I see her right there.
Okay. All right, so Ms. Sheila contends that the subject apartment was in fact inspected prior to Mr. Chow assuming occupancy in December of 2018. She provided a rental property certificate of compliance dated November 2017. So that clearly shows that the dwelling was not properly inspected by town code prior to Mr. Chow's occupancy. She provides a copy of page 2 of the rental property regulation that citing that the regulation shall not apply to units for which the building inspector has issued a certificate of occupancy within the 5 years prior to the date of vacancy. Ms. Healy does not provide the relevant building inspector's certificate of occupancy. I need to emphasize, certificate of compliance from your health inspector versus the building inspector's certificate of occupancy. Two different things. Okay, the building inspector performs his inspections under 780 CMR, and it should not be confused with our rental property regulation that references certificate of compliance pertaining to the building or the housing code. So second, Ms. Healy contains that the subject tenant was in fact given proper lead paint disclosure prior to and upon assuming occupancy. She provides us with a signed lead paint disclosure form that she acquired off the internet, which does not comply with Chapter 111, Section 197A, subsection D. All right, so I provided those proper forms not only to this board, but also to the Healys, and I offered to be an intermediary so that she could make the proper notification to the tenant. Ms. Healy's forms are generic, and they reference EPA federal resources rather than the stricter Massachusetts regulations and statutes. Forms that I provided to the board and to Ms. Healy, Mr. Healy. And then lastly, as I expressed, it's kind of tough for me to determine whether or not the Healys have done a sanitizing after the contractors have been there. But there has been another matter that he's brought forward that I'll be contacting him about off and not related to this appeal. So, to Ms. Healy.
Okay. All right, Ms. Healy, it's you have the floor.
So why does this say this regulation shall not apply to any rental dwelling units for which the Adams Building Inspector has issued a certificate of occupancy within 5 years prior to the date of vacancy?
Do you have such a certificate?
Yes, that's what we sent you.
When
Oh,
I called for a certificate of occupancy, I was told, Pam had emailed me a form to fill out. I filled it out, sent it back, and Mr. Romanek came and inspected my apartment. It says occupancy allowed, and it was signed, and that's what we were issued.
This is dated November 2nd, 2017. This is the document you're talking about?
Yes. And that's all we were told we had to do.
Me?
Yeah, Mark.
Okay.
Yeah.
All right. So firstly, I would ask that, since Ms. Healy is here, that her husband not speak on her behalf.
I'm allowing him to speak for me, please.
They're
He's
sitting
been
right next to
handling this throughout this because I'm still working.
So you only have one. All right. So first of all, the certificate of compliance for the housing code is different and separate from the building inspector's certificate of occupancy.
No, this clearly states, this regulation shall not apply to any rental dwelling units for which the Adams Building Inspector has issued a certificate of occupancy within 5 years prior to the date of vacancy.
What are you referring to?
Okay, so
The town code that you sent us.
that's number 4 on the town code. On A. Dwelling units.
No, I don't.
And the form that I was given is a rental regulation inspection. And that says occupancy allowed.
Yeah, that's what they're referring to now, what I just showed you.
Okay, so your certificate of compliance issued by Tom Romaniak was good for 1 year, so that expired November.
No, it says 5 years in this code. This regulation shall not apply to any rental dwelling units for which the Adams Building Inspector has issued a certificate of occupancy within 5 years prior to the date of vacancy.
Okay.
Not
Again,
1 year, 5 years.
Yeah, you're confusing things.
No, we're not.
The
You're
certificate of
confusing.
occupancy, a certificate of occupancy from the building inspector is different from the certificate of compliance.
Then why does it say
Stop.
specifically mention building inspector?
Stop. We have 2 forms here that Pam sent me. She emailed them to me. One of them is a rental regulation inspection with occupancy checked as allowed. That was dated 11/12/17. Also attached to that is the Chapter 2 Certificate of Compliance, which was dated 11/6/2017. We have both of those. And if I don't, then the town messed up on that because I requested a certificate of occupancy. I filled out the information. He came and inspected it.
So these are the 2 documents that they're referring to, Mark. So that's the one on the 6th, and then.
Okay, where does it say what she just said?
It was sent in the email.
And then this is the other one that they're talking about. and then the 5 years is.
Okay, so here's the regulation. Okay, so I think you're confusing things. So,
Where is, cite your regulation. Please cite where in this town code that you sent us that it says 1 year.
Brian, what's highlighted, number 4, in parentheses, do you see that document?
I don't see any document.
What I'm
You
saying,
were quoting it, saying
let me
5
speak
years.
for a minute.
Yeah, go ahead.
What I called the town, I called the Board of Health Building Inspectors. I said, I need a certificate of occupancy for my unit. I have a duplex. They sent me the form to fill out. I filled it out. Tom came and inspected it and gave me what I was needed to occupy my apartment. I wasn't told anything I needed to have anything further. I have the rental regulation inspection and the certificate of compliance.
Okay, Jerry, go ahead.
Okay, can you hear me all right?
This is Jerry Gardner, our building inspector.
Can you hear me okay?
Yes.
Okay. So what happens is that multifamily properties are inspected by the building inspector every 5 years. That's done under state 780 CMR, and that's a different inspection than what Tom Romaniak was doing. What Tom does is he does the Safe and Sanitary Housing Code enforcement. That's a Board of Health issue. But I do 780 CMR, which is building code. So when I go through a property, I inspect all multifamily dwellings, which I'm just starting the program up now because I've only been here a short time. Starting that program up now, I go in, I inspect for the 5-year certificate to allow you to continue to do what you're doing on that multifamily property. What Mark is doing is a Board of Health regulation under the Safe and Sanitary Code, which is 410, and he issues a permit for when people are entering or leaving an apartment. He's the one that does those inspections. Those inspections are totally different than the 5-year inspection that is conducted by the building inspector.
Okay, but he's saying that we don't have a certificate of occupancy. We do have a certificate of occupancy.
It's not actually a certificate of occupancy. See, a certificate
That's
of
what it
occupancy.
says on the order form, on the code enforcement order form, or whatever he gave us.
I don't know what you gave her. Can I see that?
Where do I go with this?
Yeah, I kind of want to see what.
All right. So David and Laura? David and Laura?
Yes.
Okay, so under per exhibit 1,
Yeah.
updated correction order inspection report, page 1 of 3,
Yes.
okay, administrative, failure to have rental unit inspected before 12/1/2018 occupancy. The next document under Exhibit 1 is page 2 of the 2005 rental property regulation, where Section A, subsection 4 is highlighted. This is what they're referring to, that this regulation, our rental property regulation, shall not apply to any rental dwelling unit for which the Adams Building Inspector has issued a certificate of occupancy within 5 years prior to the date of vacancy. So this is where I'm saying the building inspector's certificate of occupancy is different than
A 110 CI. That's what I'm trying to explain, but I got cut off.
I'm just more confused than that. All right, so, so the building inspector's certificate of occupancy is different from our property rental certificate of compliance. So the next document that they're referring to under their Exhibit 1 is the rental property regulation inspection. And what was given to them was the inspection form, the inspector completes at the property is underlaid by the Chapter 2 of the State Sanitary Code. Chapter 2, Certificate of Compliance in accordance with 105 CMR 410. So, for clarification, their certificate of compliance was not performed prior to Mr. Chow's occupancy, and the certificate of compliance does not have a notation that it shall not apply within 5 years, because they're conflating two
Okay.
separate matters.
If you're saying that we need to have a certificate of compliance, why doesn't it have an expiration date on this certificate of compliance that I have? If you say they're only good for 1 year, why isn't there a 1-year expiration date?
And why did you provide us information that wasn't even correct when we asked for the law? I specifically asked you for the law
And I
as part of
sent you
this
the
hearing,
regulation.
and you
And I
sent me
actually sent
something
you the
that said,
regulation.
the regulation shall not apply to rental units within the Adams Building Inspector has issued a certificate of occupancy within 5 years. That's what you provided.
No, because Stacy said just now that she got that from Pam.
That I what?
I sent you the whole regulation. You said that Pam sent you that.
No, you
No,
sent us
Pam
this.
sent me my copy, and also she's the one who originally sent me the form to fill out for my certificate of occupancy when we first bought the property. I bought the property on 10/31/17. So we did this about a week afterwards. I
Okay.
called, I said, I need to have my unit inspected for rental property. This is the form they gave me. This is what they gave me.
All right, so
And I have
Did
the
all the
email
board
from
members-
Pam, the original email.
did all the board members get a copy of the rental property regulation?
Where is this
Okay.
rental property regulation online for the public to access? Because I could not find it anywhere.
Right, so it's been in effect since 2005. I came aboard in October. We're working to revise this regulation, so I can't answer why it was never online.
Okay, so how am I supposed to know the regulations if I have no access to them?
Well, you
Unless
signed
they're
the
written
form.
on the form that I fill out or the form that I receive.
But that's neither here nor there, okay? I informed you
No,
of what
that's
the
very
regulation-
No,
important.
that's very important because we are new to this property. We're new to renting property. We went through the proper stages to get what we thought was what we were getting to rent our unit.
So you had an experience with another inspector, you should have questioned him on that, right? So when I give you the correct information.
Where is
all
the
I-
correct information? We haven't gotten the correct information. We
Well,
still
you did,
haven't
because I
gotten the
sent you
correct
regulation.
information.
So anyway,
If the
Oh,
certificate
anyway,
of
on
compliance
page
has, what did I do?
Pam,
so on page 3 of the regulation, it states that that no dwelling unit need to be certified for occupancy more than once in any consecutive 12 months. Okay, all that notwithstanding, the fact is, there was no pre-tenancy inspection done before Mr. Chow's occupancy.
But I'm asking you, we have no access to information. The certificate of compliance has no expiration date on it. And the certificate of occupancy lasts for 5 years. So how am I supposed to know this if I have zero access to this regulation?
Okay, so moving on to the next matter. So what's your challenge on the lead paint disclosure?
No, we're still on this one.
We haven't resolved the certificate of occupancy.
The board will
Because-
resolve.
yeah,
The board will resolve that.
we'll resolve this, as we go through. So it's my understanding that you guys received the wrong forms in the initial inspection. Is that right?
No.
They
We
got the
haven't
right
received
one,
any information.
but it's expired.
what states that this is expired? My form right here, my certificate has no expiration date on it. It just has a date of issuance.
So that's
There's
what-
nothing on here that says it expires a new year, expires when tenant vacates, nothing.
Okay.
Then there's no online access to any of those regulations. How am I expected to know these things if I wasn't told them or they're not on the certificate?
And the only thing Mr. Blaisdell sent was something that said, this regulation shall not apply to any rental dwelling unit for which the Adams Building Inspector has issued a certificate of occupancy within 5 years prior to the date of vacancy. That's the only thing he sent us.
Okay,
So
what
I
information
haven't
did you,
even seen what he's referring to right now.
what information did you request?
The reasons for this
Code infraction.
code infraction.
You sent the regulations, right? Okay. Okay, so what am I, in the timeline, what am I missing then with that?
Regulation requires, so what's before the board is the regulation requires that pre-tenancy inspections, the pre-rental inspections be performed before Mr. Child's occupancy. The data they provided, the data I provided to confirm that a pre-tenancy inspection was not performed prior to Mr. Child's occupancy.
Okay.
Next matter, the lead paint.
One second. David, Laura, do you have any questions on that?
Not really. I'm just sort of thinking like, can't we just sort of, I mean, there are compliance issues, I understand that. Can't we just sort of set like a date certain after which Mark goes back and checks the boxes, and hopefully it's before May 20? I mean, maybe that sounds simplistic, but
So you're asking if Mark can go in and do the inspection?
well,
No.
I thought there were outstanding and that there were extensions on some of the compliance issues.
Yeah. I
There
think
is,
were.
because we're having issues because a lot of places are not open due to COVID. We're working on getting a lead inspection done. We have had contact with the person. He's not back to work yet. So we're still waiting on a date for him to come in. We've complied with almost everything else. We had all the other inspections done. They're working. He has one last thing to do on the electric and he'll be finished with that. What else was on there?
Yeah, we understand that this whole COVID thing is throwing a wrench in all that, so we'll definitely take that into consideration.
I mean, we are willingly complying with all of this, but we do disagree with the certificate of occupancy and the lead disclosure because we did do those things. And as far to our knowledge, we had no knowledge that any of these expired or other than the 5-year expiration date that we just found out. But this is what we were given. We asked for a certificate of occupancy. This is what we were given. And there's no expiration date on it or any expressed that it expires at any time. You know what I mean? Other than the 5-year certificate of occupancy. I mean, like I said, we just bought the property a week prior to getting this.
So do you understand that there's a difference between the two?
I do now,
Okay.
but
So can we move
that
on
still
to the
doesn't,
second?
like I said, there's no regulation available to anybody online.
Okay, well, I apologize for that.
And I still haven't seen what you're referring to. What you sent us says what I'm citing.
All right, well, you're not going to find anything in writing saying the certificate of compliance is different from the certificate of occupancy. You just have to take my word for it. You have to take.
Come on, man.
No, I want to see it in writing because you're enforcing something. It needs to be in writing, and there needs to be an expiration date on a certificate of compliance if there's an expiration. If there's a hard 1-year expiration, it needs to be on there.
Okay, well, under the pre-tenancy inspections that I do, I do put that notice that it does require.
But you didn't do this
I can't
inspection.
correct-
You weren't involved in this at all. And
I
now
don't
you're
think-
coming in and enforcing something that you have nothing to do with initially.
He's enforcing the code, that's his job, and yes, he's not at fault for giving the wrong information, the wrong forms, and doing stuff that somebody else did. We're just trying to correct that.
Right,
So we're
as
trying
are
to-
we.
Trying to do the right thing.
Right, so I can't, I
But why
can't
didn't you
correct
send
what
us
another
the
inspector
correct
did.
information initially? Why did you send us the wrong information?
I didn't.
Why didn't you send us something that said 12 months instead of something that says 5 years?
Because that content of the 5 years is within the regulation, okay? I can't, what's the word, redact that information out of the regulation, okay? So when I send you something wholly and entirely, I can't blot this information out. This is a town regulation, all right?
Town regulation that nobody has access to.
I think that, all right, well, again, that's not something I had responsibility for, all right?
Well, you work for the town, so you're part of it.
It doesn't mean, okay, whatever. So let's move on to the lead paint disclosure. Do you understand?
We're still on this occupancy
Okay,
thing.
can the
Sorry.
board make,
I think we're gonna move on. David, Laura, any other questions on this first part?
Nope.
No.
Okay, all right, we're gonna move on to the lead paint.
okay. So, did you understand my presentation that the state has their own forms for lead paint disclosure?
Well,
Mr.
That's your
Healy?
assertion.
Healy?
I mean,
I took my lead disclosure from a legal website.
Do you understand the state of Massachusetts, or the Commonwealth of Massachusetts has their own forms established for lead paint disclosure?
No, I didn't. And that's why I
Okay.
used one from a legal website.
And when I presented them to you,
Now let me get this straight. You just sent me an email saying this is the proper form, and that was the end of the email. You didn't say, I'm gonna advocate and get the tenant to sign it. You said nothing of that. You just sent it to me. You said this is the proper form versus what you have. Or what
okay, and
I
you
have.
understand that Mr. Chow is present? Ms. Healy, you understand Mr. Chow is present? He was party to every email that we've had?
Right, I'm aware of that, and I can pull up the email right now and read it.
So, Mr. Chow,
Yes, sir.
and what is your recollection of that conversation I had with the Healys about the proper lead paint form?
Again, you gave them there's a proper lead form attached to the email right at the bottom. For
Do you recall that I offered to be the intermediary?
yes, it does say that if you wanted that filled out and for that inspection to take place, not only would you be the intermediary, but you would help facilitate the inspection itself.
Okay, thank you.
I'm looking at the email right now that you sent me, and I can hold it up to the computer, but I doubt you can see it. It says on listed number 2, please find attached, hold on. Please find attached the approved standard addendums for lead paint disclosures. This does not negate a comprehensive lead paint inspection being performed. That's the end of the lead paint disclosure discussion. That's it. It does not say that I will negotiate something between the tenant and signing it. It says nothing of that sort. And I can email that to you, Mr. Hoyt.
And what's the date on that?
That is April 21st.
Okay.
That was the
What-
one that where the, you attached the proper lead disclosure.
And have you filled that form out and submitted to Mr.
No,
Chow yet?
because we're
You did
waiting
not
for the-
ask me to, and you did not state. You just stated that that was the proper form. You did not say fill it out. I'm gonna have your tenant sign it. You said nothing of the sort. You just stated that it was the proper form. That's it.
Okay,
And I will forward you that
All right.
email, Mr. Hoyt.
Mark, is that the email that you're talking about? Or, don't know.
I'd have Inconsequential. What's
Okay.
before the board is the fact that I've given them forms. They're using the incorrect form.
Okay, David, Laura, any questions?
Not for me.
No,
Okay,
Mosey?
Matthew, anything from you?
No, nothing on the merits. I mean, I'm curious, Mark, has the cross metering been fixed?
Yes, it has. Actually, it's been fixed on your tenant's behalf. They are now, circuits of the tenants that are on the landlord's circuit.
Okay. That was my only question.
They stated that that was gonna be finished up on Sunday.
Ms. Healy, say that again, I'm sorry.
I said I stated that with the electrician will be finishing up on Sunday.
Okay,
It proved to be a bit more complicated than at first at the first look at it.
okay, thank you. Daniel, anything from you?
No, I don't have anything to add.
Okay. Okay, so, David, Laura, we need to make a motion or recommendation on what we ought to do. We can, uphold this, we can change some things, we can deny it, I guess is the proper word. Any thoughts?
Nothing beyond what we've discussed.
Okay, so we need to make a motion or a recommendation to uphold Mark's findings, change
Mr.
them.
Hoyt, I sent you that email so you could read it for yourself. I
Okay,
forwarded that email to you.
Well, it's not so much upholding Mark's findings. I mean, his findings are real and they're true and they need to be addressed. The question, I think, is in terms of dotting all the i's and crossing all the t's, making sure that we are up to current code. And my understanding is the landlord is trying to get there. And you know, is there any wiggle room in sort of saying, like, particularly in the pandemic, can we sort of set that date certain, like 2 weeks from now? And if something comes up, you know, that she just sends us documentation that she's tried and we can extend further. I mean, there's nobody in the wrong here. It's just we're trying to get everything right.
yeah, so I think it's just a matter of getting these, proper forms submitted, right? So that the lead form, Ms. Healy, that you have, that Mark sent in that email, I just read it. You had the form. You are aware now that that needs to be completed. I think that can be done quite easily and relatively quickly. And then, when is the next, Mark, when is the inspection the next time through?
The 18th.
The 18th? Is that correct, Mark?
The 18th.
Yep, 18th, okay. So the next inspection is on the 18th. And I think you think you can get most of the stuff done at that point, or all of it?
I'm not sure. We're still waiting to hear back from the lead inspector to see when he can come and do it.
Okay. And that's the main, the electrician part is done, right?
No, not
He
done.
should be finishing up this Sunday.
Okay, that's right, Sunday.
So the matters before the board
Yep.
would be these two matters. And so, I would seek that you vote to affirm the order as
We
written.
can't hear
I
him.
can't hear him.
Yeah, we
So
can't
he's-
hear him.
He's just restating that he's asking the board to reaffirm or uphold his orders as stated. So I'm just kind of waiting for a motion or recommendation from the board so we can.
I guess I would move to affirm Mark Blaisdell's orders with the caveat that compliance be within limitations of the pandemic, that the landlord, if she is unable to comply, that if she provides documentation, she tried, what?
So David,
Yes,
it's not the entire order. It's these two particular matters,
okay,
okay? There's nothing related to the pandemic that prevents the property owner from doing a proper lead paint disclosure to the tenant.
I thought she did that. I mean, it's in the public record now.
Oh, she has not done the form.
Okay.
Did you guys read the form? Because it says exactly the same thing as the other form that he sent. I mean, excuse me if I didn't get it off the mass.gov website. I didn't. I got it off of a legal website.
And it's incorrect because it refers to EPA federal standards, which are not as strict as Massachusetts statutes and regulations.
Where am I going? Great.
So as far as the remainder of the correction order, for the record, I have granted extensions to the Healy's. They have failed to mention that, so did I. So the remainder of the correction order is not at issue here. It's just these two matters. Did she have the rental inspection performed in accordance with town code? No. And then did she give proper lead paint notification in accordance with Massachusetts general law and regulation? The answer is no. So therefore, I ask the board to affirm the correction orders as written.
Okay, so if I fill out the lead paint disclosure, you're gonna have the tenant sign it? Because that's what you said earlier.
Sure.
All right, that's fine. It wasn't written in the email. He just stated, this is the proper form. That was the end of story. There was no indication that he wanted me to fill it out and have the tenant sign it, or he was gonna have the tenant sign it. None of that was conveyed.
But you have the form now, the correct form now.
I do.
Okay, so you can get that done. That's not an issue.
Okay, so Mr. Blaisdell is gonna do that?
He said he
The
would-
tenant refuses to have any contact with me.
Mark said that he would assist with that.
Okay, I will fill it out.
Okay.
And as far as the compliance of occupancy and compliance, I'm sorry. I went through the proper channels to apply for that stuff. I filled out the forms. That's what I was given. There's no expiration date. There was no instructions that I was to have it re-inspected after 1 year or after new occupancy if it was within the 5 years. And there's no public access to any of that information.
And again, I apologize for what my predecessor did and did not do.
And we still haven't seen
Stop.
what he's citing. We still haven't
Yeah,
seen that.
Stop. The fact is, we were not given the proper forms, apparently. We were not given the proper information. That is not our fault. And the
Okay.
information is not accessible to the public via the town hall.
Right.
So how can I be at fault for something like that? If you want to inspect the apartment after we're done with the compliance, inspect the apartment. I have no problem with that.
But it shouldn't be past due, certainly. Because we still haven't received the proper documentation. What you had sent us is something that says, as I cited in our exhibit, the 5-year compliance.
Does your certificate of compliance currently have an expiration date on it now? When you issue a new one right now, is there an expiration date?
He stated earlier that he does put that on there.
Okay, so there's not one on mine.
Wait, are we talking about fines here?
Oh,
No.
Okay, I mean, why don't we just stop arguing and get the stuff done?
right.
I think I've asked for a motion to
20 minutes ago.
recommend, so can we,
All right, let me try it again, because as Mark said, he's got the extensions written into his orders. And so let's vote. I move that we uphold Mark Blaisdell's orders with his extensions, recognizing that further extensions may be necessary.
again, the extensions are a different matter. It's not with these two things.
Thank you. This is not what we're talking about. We're talking about him saying that we weren't complying with the certificate of compliance and the certificate of occupancy.
Okay,
Well, then I move that you provide the documents that he wants, and
I did. I provided the documents that the town issued me.
then send them to
okay,
the chairman of the Board of Health, and we will review them and make sure and get back to you.
okay, no. All right,
I'm
Okay.
gonna make I sympathize with everybody's situation, but I'm gonna go ahead and make a motion to uphold Mark Blaisdell's findings. As
Okay.
reported.
do I have a second?
All right, I say no discussion from my part.
Okay, there's no further discussion from the board. Again, roll call vote. Laura,
Yes.
David,
Yes?
and it's a yes for me, so motion passed.
And
Okay, thank you, Mr. and Mrs. Healy, for attending to this, and the other parties. I'm sorry, Daniel and Matthew, thank you.
Thank you.
for participating. Mark, you'll be in touch with them?
Yes.
Okay, all right. Thank you.
Thanks. Have a
All
good
right,
night.
next-
All right, bye.
You too, take care.
Thank you. Good night.
Yep,
Hey, Matt.
take care.
Bye, Mark.
Okay, next on the agenda, I can find the agenda here. We have the hauler regulations. And again, Mark, can you hold on one second? Did we get any emails, or I saw somewhere that Pam got some information from the haulers through email?
We did. Yeah, yes, we did. Kyle Del Molino actually had the most pressing one in terms of the extra cost regarding recycling.
Okay.
But yeah, I'll let Mark go forward here.
Did you hear any other information on the map, or?
I never even knew about those.
Okay, all right. Thank you. Thanks, guys. All right, so I guess my issue is that we had to cancel that meeting with the haulers because of the COVID-19 deal. And I have not seen those emails because we did ask if you couldn't participate to send some stuff in. I did not see those emails or any information, so I don't know how much we can discuss on the hauler stuff.
Well, Pam had, oh, that's right. You weren't at the meeting. Yeah, Pam
Right.
passed out, she passed out copies.
Okay,
Oh.
so do you guys have enough information to move forward with this then?
Well, I guess I would say on my part, I mean, you know me, I'm pretty motivated about this.
Yes, I know you are, and that's good.
And so, if we are meeting on the 20th, I think by then I can have, and Laura, Laura and Pete, were you able to review the past documents? I think I recirculated them, or?
Yes, I did review them, not probably in as much detail as I should have, but I did look through those.
That totally fine, totally fine. So, I mean, one of Kyle's main points is like, why don't we have a sticker system? And I will say, Mark said this months ago. This is back in the dark ages before COVID. And so, how about if I were again to put up something? And again, I think we're aiming for that June, mid-June deadline for the RDP points, and I will have something out in a week, maybe a few days longer, so that we can look at it and maybe take some serious action on this reinstating the regulation.
So is it, again, it's the commercial waste is the one issue, correct?
Right.
And the second is if things aren't picked up by the hauler, what's left behind? Is it a sticker? Is it a note? Is it whatever?
Right. We are enlisting the haulers and not only, complying. I mean, Adams has mandatory recycling, but it's like, who's going around rooting through trash? And we are basically enlisting the haulers in this effort. The enforcement is, I recognize, vexed, but it is, and I think we should probably check with Pittsfield, because they have dealt with this. Is like, if someone clearly has put in a lot of returnables in their regular trash. Now, I know we're allowed to do that these days, but that we have a sticker available for our waste haulers to slap on. And it's basically tracking how well we're doing with recycling and having a little bit of teeth. And so I appreciate the difficulty here, but I would like to try the encouragement approach. So let's see what I can come up with.
Okay. So we'll put this on the 20th?
Yes, yes, please, because Linda Cernick is very concerned. We haven't been meeting.
And you're in contact with her, and so she can be invited to that, I guess?
Let's try it. Yes, let's indeed. Yes, I will ask her. But even if not, she'll give me, every time I email her, I get 15 emails back. So I have plenty of information.
Okay.
Perfect.
Laura, any discussion or thoughts on that?
No, I have looked through the information as well. I'm not positive that I have it all, because some of it is historic to me. So do you remember what email thread, David, that you resent everything on? And was that everything?
I will revise everything give it a new version number.
Okay,
I love version numbers.
fair
I
enough.
haven't gone to decimal points yet, but yes, I will
Okay,
make it
Thank you.
clear that it is the current one. Thank you.
Okay, so I guess we'll continue that discussion on the 20th then, so. Okay, the next on the agenda is the tobacco capping. I did get some information from town council on the questions. I did send that to both of you on what I asked based off of the meeting that we had in February, I believe. I made those edits, sent it to him with the questions that we had, and got his feedback, and I sent that to you and incorporated that into a new draft. So you have our February draft and you have our draft for tonight, May 6th. So, and Laura, you did have some edits
I
as
just,
well.
those are
questions?
just my, yeah, final thoughts on,
So,
I resent it because I did, my original edits were from the February, I think, but I did send
Yeah.
from the newer one to this afternoon.
Yeah, I think I agree with everything you said. Yeah, it's fine.
Okay, so I guess as going through this, you know, these final thoughts and edits, I will say though that town council did not have any issues with the wording of it, so just take that into
Yeah, I
consideration.
don't have any objection to as is. Those are just the final things. So
Right.
if we submit it as is, I'm totally fine with that.
Yeah, I am too, either way. I just kind of wanted to go through and
Sure.
with your suggestions and see if we can come to a consensus with that. And I'm gonna find my
I think Ed was well taken, saying that places where youth congregate. I think in that section, we basically say the Board of Health reserves the right to name additional sites in town as whatever, as the situation evolves here.
Yeah, let me start from the top here, and then we'll work down to that, David. So
Okay, good.
in the first section A, it's suggested that Laura says we suggest taking the word suggesting out, I guess.
Fine,
So,
yeah.
and I'm totally fine with that. I mean, given the evidence that's out there, that's been there for years, that you know, tobacco smoking does cause issues, and you know, it's just a matter of semantics, I guess. And so I'm fine taking that out. And David, you agree?
Yes.
Okay. And looking at section A, do we have any other amendments, section A? Okay, hearing none. Section B, doesn't seem like there's anything there. Section C, Laura suggested that instead of writing as defined herein, is we capitalize anything that is defined.
It doesn't really make any change to the document other than easier to read.
Yeah.
Yes. I love it.
Okay, all right, so, so I'm fine with that too, so I will go through, and make those edits as well. The next suggestion is that paraphernalia is not defined. Should we define that? Go ahead, David.
Well, as a child of the 70s, I think it's obvious, but
I mean, I don't know that it needs to be defined.
Yeah, I guess my issue too is that if we where do we come up with the proper definition from this? Do we use Webster's? Do we use, Wikipedia or? So I guess that's part of my thing. If we, this is the language that we got from.
Right.
And
From,
that's.
other entities, and
Yeah.
I'm thinking that we'd have to do a lot of wordsmithing to define
Yeah.
some of these
This,
things.
this is past muster with AG and other towns. I don't think we need to fuss over that.
Yeah, I kind of agree. Laura, are you okay with us not defining?
Totally fine.
Okay. All right. Next suggestion, again, defining cigarette.
We defined everything else, just lacking. I don't care if it's in there or not.
Right. I was, after seeing that in your comment, I was kind of curious why it wasn't defined.
Yeah.
Because, so again, it comes down to where do we get the wording to define that if we add it in?
Right.
David, do you think that we should add that in?
Again, I would say that
Don't need to.
this has passed muster. I think, who's going to challenge it? I mean, yeah.
Okay. I'm fine either way, on it. Laura, any?
I don't really feel that strongly about it. I just noticed it was missing.
Yeah. Yeah, it is.
I thought it was odd.
Yeah, it is curious why it's not in there. But okay, I guess we'll leave it alone. And then, moving down in that section as well is, the terminology of, non-residential versus commercial.
I didn't know if it just seems odd to define something on what it's not.
Yeah.
But if that's the actual if that's how it's referred to as, we should leave it, but it seems odd.
Yeah. Right. Yeah. I actually agree with Laura on this one. One always runs the risk of someone being able to come up with some way to slice it. But yeah, if we say commercial, it's fine.
Yeah, I guess I'm kind of torn on this one because it's almost, I don't know. I don't know. I mean, I'll change it for now. I guess this is kind of this might be, again, if we change it, I'm gonna have town council look at it and note that change.
Yes.
See if he's fine with it. Cause it's, again, they might be defining it that way for a certain reason. So I will make that change and note that when he gets
Perfect.
a read through, so. Okay, good. All right, towards the end of section C, it's just again, wording issue here, suggested to change, to who must possess documentation, instead of who can produce.
Yeah, I didn't have an objection with the change there. Am I still on?
Yes, you are. I'm
Oh.
just reading it again. So is this a, I guess it's at the bottom of the statement there, or the last part of that sentence is that it's referring to showing somebody, I guess, that you have this sales certificate. So is it, in that case, you're producing it for somebody to view as opposed to,
Yeah, on this score, I mean, we're gonna get to this later, but, we're gonna deal with the issue of whether we are just going to rely on, the tobacco awareness program, which is, from my experience, has done us well over the last couple of years. And so I'm thinking that, just leaving it as is okay.
so Laura, I guess, what was your rationale for wanting that word changed?
I didn't read it as also producing it so that somebody could view it. So I think we probably should just leave it the way it is.
That's the way I read that statement there. That's why I said that, but I don't know. I'm not always the best with.
I think it's fine the way it is. I don't think we have to change it. Because I didn't read it that way, but that does actually make sense that they should have to produce it in some certain circumstances. So,
David?
Let's leave it.
Okay. Section B, part 2. At the end there, the statutes and regulations and Adams zoning bylaws, and I think that's a good suggestion. It obviously makes sense.
Yes.
Okay. So we will make that change. Good catch on that, Laura. Okay, section E, at the very end, part E must apply within 30 days. So the question here is prior or subsequent. So thoughts on that?
yeah, it was just unclear to me. So
I thought it was clarifying. So I need to go back and look at that.
So it's section E. It's all the way at the end. It's right before section F. It's the last thing. Applicants who purchase or acquire an existing business that holds a valid tobacco product sales permit at the time of the sale or acquisition of said business must apply within 30 days of such sale or acquisition.
This is actually, I think Pittsfield has gone through this, and I think they were extending that to 60 days.
Okay, so
must be subsequent then.
And I think the 60 days then wasn't business days. Let me check the Pittsfield regs, and I'll check with Gina, because I think this is the one that they were, one of the timeframes that they were dealing with.
okay, so now we've got maybe changing that to 30 days, and then this would be subsequent such sale then, right?
Right, right. Yeah, I mean, business, these places are open 24/7, not 24/7, but they're open 7 days a week. And so
Yeah.
they're all business days.
Yeah, right. Okay. Okay, good enough. So we'll make that change there. Section F, number 2, right there. I had noted also cannot be linked to sale of non-tobacco product, question mark. Laura, I guess I'm confused on the question here.
So I was just thinking they're maybe not associated directly with the second one, but not having like you buy I don't know, you buy a 6-pack of something and here's a free cigar with that. That's not necessarily covered in those.
Just trying to see how I missed which section is this?
Section F, number 2.
And yeah, I'm still struggling trying to find it for some reason. What page are we on here?
So I have it as page 6.
Yeah, page 6.
Oh, okay. I was too far beyond that. Okay. Cannot be linked to the sale of Oh, yeah, I wasn't sure that wasn't in kind of the original state code about giving away freebies for buying tobacco products. But I think Laura's addition, that it may be redundant. I say may, but if so, it's not unwarranted.
Yeah, I'm fine if it's going to be redundant, then I'm fine with keeping it in there anyways.
Yeah, I would say go for it.
Okay. Yeah, I'm fine with that as well. All right, good. Okay, looks like section G, we're good with that one. If anybody has anything now. Section H, we are also okay. It's section I. So this is page 7. It's just a question about locked.
Well, yeah, tobacco awareness picked up Val's on this one. And so again, I think this is sufficient. Laura's addition is again not unwarranted, but this is one of the things that Jim Willis's group looks for, and they caught Val on it, and Val's on it, and there's now a lock on their and so yeah, I would. Laura's language is much clearer.
Stemming from some DEA stuff and controlled substances, definition of locked.
Well, that's right. You're the veterinarian.
So are we, Laura, are you suggesting that we replace this language with the word locked?
No, I think
What-
she's saying,
No, the opposite of that,
yeah,
So adding it to
correct.
yeah,
locked
yeah.
and secured to prevent.
Right.
Locked, yeah. I would say locked and secured to prevent
Right.
that, yes. Yes,
Okay,
I like it.
yep, makes sense, I like it too, good. All right, J and K, we look good there. L, M, N, all looks good, unless anybody has anything. O looks good as well. And then P, violations.
Well, that, going back to the certification,
Yep, go ahead. O,
because this was the one where I was trying to stand firm that we actually specify tobacco awareness program. It's a state grant funded program. It's been successful over, multiple municipalities. They maintain a database. They have, and there are, it's not just, oh, watch this video and get a certificate. There are actually testing requirements every 2 years, and I would firmly advocate for specifying, as we did in the original, that tobacco awareness program is our surveillance and monitoring. And we might add that, obviously Mark also has authority here, but that for the random inspections and the checks and maintenance of certification lists, I would go with tobacco awareness.
yeah, I guess, I remember that discussion. I think my stance was to not define or limit it to a few of them, even if we listed 5, because who knows, 5 years from now, there might be a different certification from a different entity that would be fully, that would fulfill this certification. And if it's not listed in here, then it would not count. So that was why I was opposed to that. I'm not opposed to using one certain thing or one from the state or from whatever Jim suggests. I'm not opposed to that. I'm just opposed to limiting that by specifically stating them in here.
The one from the state is actually based on what Jim has created, number one. Number two, many of the chain stores have their own programs, but they're sort of dealt down from on high, and they are not coupled with a surveillance and monitoring, and it's also harder to keep track of who has been certified in terms of the clerks. So I really feel strongly that we should specify one certification program, and that it's not onerous, but it basically kind of keeps things within our box. And it's a maybe it's a Berkshire County box, whatever, but I think it works for us.
So here's just playing devil's advocate again. So if we specify one, David, what if somebody has one that's approved by the state, but it's not that specific? They'll have to go and recertify.
So it takes them an hour or two to go through the program, take the test. It's every 2 years. It's not onerous, and it basically makes sure that all the clerks are on the same page that tobacco awareness is going to be looking for when they go around and do their their tests. I mean, they send ringers. They come and ask for books, for the permits and so forth. And it's so that everybody knows we're all on the same page. This is just what I would, I mean, being through this and talking to Jim Willis multiple times, it seems to me much simpler. And by the way, I mean, one of the arguments is that, well, some of these clerks work in multiple towns. Well, you know, most of the towns in Berkshire County are under TAP, so that it's not like they would have to take 2 tests.
Yeah, I'm just trying to find the original one with that language in there. And I can't find it, but, Laura, any thoughts on that?
Yeah, I mean, I appreciate David's insight into, you know, everybody being on the same page, but I feel like I think it could be limiting, especially if you have chain stores that already have their internal education system. Is that going to be a deterrent? I don't know.
I don't think it's I don't think it's limiting. I think it's empowering. It's that.
Jay, what time do we need to be out of here?
You have plenty of time.
Soon?
Half hour, 20 minutes.
Okay, all right. I've been looking at the time, I'm a little worried.
No, take your time.
Yeah, I kind of, I agree with Laura on this. I think it's difficult to, and I can't find the original one for that wording, but I know that it does specify.
I've got it. If you want to, I mean, I'm looking at it right now.
Yeah, go ahead and read it for me, David, please.
And I was, unfortunately, it was scanned, and so it doesn't. I'm having a hard time finding who are where that line is on tobacco awareness program will be our agent for. But let me email it around, and I will send it. I mean,
Yeah, I think that it's, because we changed it to say, an approved retailer training program.
correct.
As opposed to specifying that one that Tri-Town had. And again, I think, you know, I can appreciate you saying that we all need to have consistency with that, but I just think that it's limiting. I mean, if something's approved by the state or nationally or something, I'm not, you know, I think that would be fine if it's a legit. And obviously, Mark would be the one to approve that.
No, it's actually us. Yeah, I mean, it's our
He's
call.
going to be looking at it and saying, you know, there's possibly a violation there. You know, we're not going out and looking at these.
Well, I mean, he does, he also has authority. It's just that we are calling in an additional resource that, by the way, also gives us access to legal help from DPH, and it's, I mean, we wouldn't lose that, but what we would lose was the possibility of having the training programs being less rigorous than what TAP has.
So, Town Administrator Green just walked in. I'm going to put him on the spot, if you guys don't mind, and ask him his opinion on this.
Shoot.
So basically, we're talking about these tobacco certification programs for
Retailers?
retailers.
Yep.
And for the original document we got, there was a program, it was specified in there from the program that Tri-Town uses, that this would be the only approved program. Mark had kind of brought up the point that there's other ones other than that. So we kind of voted to change to say, an approved retailer training program, as opposed to limiting it to that one.
Yep.
And we're kind of back to that now and kind of discussing, so I guess my feeling is it just kind of, like I said, it limits it to one, as opposed to having several that could fulfill this requirement. And I kind of feel that it would be tough to list all the ones in there. If we did that, that's why we changed that, but also I think David's saying he just wants that one from Tri-Town.
Tri-Town has a good program. Jim's excellent with his tobacco control. I wouldn't see where the board would probably need to change. But from a procedural perspective, you might want to keep your options open simply by saying an approved program. That doesn't mean it's not going to be Jim. Doesn't mean you're going to get rid of Jim. Jim's going to want that language in there, and I don't blame him because that's his, his program.
And you said it better than what I could have, and that's what I'm saying, that you don't, it could be Jim's, it could not be, you don't want to.
If you say it's Tri-Town, it narrows you down to Tri-Town. If the program falls apart down there, Jim takes another job, and he's, that may happen. It now limits you to it, and it may be a substandard program. So just by putting that language in there, it gives the board the option. That's my take on it.
Jay, I think we can, I think we're big enough to understand that if Jim's gonna leave and the TAP program is defunded or whatever, that we'll have enough, we'll have enough lead time that we can adjust. You didn't hear me saying this before, but having had, and I know you've had experience with Jim too, is that he's got a very robust program.
Yeah.
And I like the idea of all of us being on the same page. His program covers 80% of Berkshire County residents. It's a way.
David, let me interrupt you for a second. I guess I'm trying to understand, is your issue more that you don't want any other program to fulfill this requirement other than the Tri-Town program?
I think it makes it easier if it is a Tri-Town program, because there's one place to go, and then we don't have to sort of say, well, if 7-Eleven has their program and or Walmart or whatever, that we have to look at it. We've got someone, we've got the Jim Willis and the tobacco awareness, that we have a single source that is validating. If that goes away, then we would have to reinvent. But I'm just saying, like, why create a new wheel when we've got one that works?
Okay. I don't know, Laura, any other thoughts on this? I guess we'll have to kind of vote on this.
I guess I was under the assumption that any big chain that has their own in-house education and certification on this would be state approved. Is that correct?
No.
So they don't have to be state approved?
No. So.
Well, I would assume that they would, because they have a permit through the state as well.
Pretty sure that that's not the way, and the state accepts much less. And so I think if you want to accept other programs, and I will check on this myself, but I'm pretty sure that the state will accept certifications that are less robust than what we have. So it's again, I don't think we're limiting ourselves, and it's not like,
Well, we're not limiting ourselves. I think that we're limiting the retailers of what they can do to fulfill this. I think that's where it comes from. But I also think, just stating the one in there, it's, I agree.
I know,
That goes away.
Jim,
We got to come back to this.
I know Jim tuning his own horn, but I had a problem when we reinstituted tobacco awareness a couple years ago, because we left our subscription lapse, and when they came back, it was actually Val's that complained, because it's like people came in sort of asking him questions. Yeah, but he was compliant, and it's just that he wasn't used to this. What Jim would say is that, yeah, the first year is always rough, and then the vendors actually appreciate, because he holds a very high standard. The program
David,
holds a very high standard.
David, I don't think anybody's questioning the validity and the standards that Jim has set in that program. We know that is a great program. I think it's just, and I think the question is do we want that to be the only one? That's the question. I mean, Jim does a great, there's nobody arguing that. Jim does a great job. That program does a good job. That program is high quality. And that's if you want to put it, that's the Harvard of the tobacco stuff. Are we going to accept something from MCLA, I guess?
No, don't go there.
That's what I'm looking at, and I think it's all fine. If it meets a certain standard that's approved, I think we can deal with something that's not from Harvard.
Then I would strongly suggest that we add language that if another program is accepted, that it be approved by Massachusetts, by the MHAB or whoever, MHOA, and that results are conveyed to TAP within 30 days of completion, so that TAP can keep those vendors on their list, because they have a 2-year certification schedule, and it's, if you download the file, you can just see it's like so and so passed such a date, and their certification expires 2 years hence. So I would strongly advocate that there be that level of oversight, that we at least use TAP as oversight.
Okay, I'm just it says it's defined in section C.
Yes. Yeah, it's, yes, right, certification, that's right, but it's not.
So I'm trying to see what the actual, tobacco sales certification.
Oh, okay, it's under T, that's why.
Yeah, tobacco sales certification, a training program approved by the Adams Board of Health that requires a training which must be successfully completed by all tobacco product sales clerk engaged in the sale or distribution. So does that
Yeah. It says
satisfy? It would be, yes, it would be approved by us.
Yeah, for the purposes of this section, the Adams Board of Health has designated Tri-Town Health to administer the tobacco retailer certification program. And so basically we were deferring to TAP. But if we are going to open certification to others, I firmly advocate that we keep the same level of rigor approved by the state and kept on our list.
Okay. So David, you're suggesting going back to what you suggested before is adding in the program from.
The TAP is our preferred certification program. If you choose an alternative program, that it is approved by the state Massachusetts Department of Public Health, and that certification be submitted to TAP within 30 days of completion.
Okay. Laura, what are your thoughts on that?
Do currently other certification programs submit? Like, is there a requirement for that to submit to TAP?
No.
There's not.
No, I mean, that's
So
the point.
so you're basically wanting to maintain a list of everybody's got a certificate locally. That's
Yeah, so we
okay.
can look it up. And I did. It's like, and John Sharon and Wanda Sharma. I mean, it's like they're all on the list. That and these are new people that have applied for certification, and they've gone through Jim's program, and so you can go and look and see. You know, anybody. It's an open list.
All right, I guess just for the sake of time, because I have to get out of this room here pretty soon, so they can wipe it down before the 7 o'clock meeting. But I guess let's just put it to a vote. I guess for section O to leave it as is, or to amend that to include TAP or sending the approved training program to TAP, so they have a record of it.
I would go with, I would approve that, and so you will send out the draft, and I will go over it and basically put in my language, and we can go from there. Okay.
Okay. Yeah, I think yeah, David, I think that's a better suggestion. Is I'll leave it as is for now, and you can add that in if you want as amendment, and then we'll make
If I want.
final draft.
No. This is a demand, but that's not.
I want to, like I said, I want to get through some of these edits that we can agree on, because
Yeah.
we've only got a few minutes here, so I was kind of hoping that we can get through this fairly quickly. But all right, so moving on to section P, the violations. Laura had suggested here, will collection of fine be problematic if suspension of certification? Is that just doing that?
Yeah, I remember, I think David had, didn't initially want to find the sales clerk, and I had started thinking about that. I mean, who's going to track down a 22-year-old to get $25 from him? How is that going to happen?
No, Laura. You look at the state law, and
Yeah.
and they get the $1,000 fine. I mean, that's the state law now.
The clerk.
The clerk, yeah.
Okay.
Whoever does it. If you go back and look at the original code, or the one that
The
was
new.
passed in November, whoever infracts gets that $1,000 fine first time. It doesn't matter if you're a 17-year-old kid behind the counter. And I think Ed should look at this, because I don't know if there's any wiggle room there, but we have to impose the fines according. We can't impose less than what the state says.
So we need to correct that to $1,000 to the.
Yeah. Well, I forget what the scale is, but I looked at that several times, and it's like, first infraction is like big bucks. Second infraction, I think, is 2,000, and third is 5,000.
5,000. Yeah, I saw that. Yep.
And-
I thought that was for the.
Yeah,
owner.
I believe that's for the business.
I think it's for the.
it says whoever violates. It's not whichever business violates. It says whoever violates this law.
All right, yeah, I guess we'll have to go back to that, because
Yeah, please
this is
do.
separated out for the clerk and the business.
Yeah,
Right.
please do, because I thought it was pretty clear. Whoever violates.
Okay. All right, yeah, okay, so we'll come back to this section P then as well. And we'll wrap it up here, so. So I think the last thing on there is just the date effective, and I highlighted that because obviously we don't know that, because we would obviously have to approve a final draft, and then,
Right.
and then, put it out to the public and have a hearing, and, or
Except for the
public
menthol,
comment.
except for the menthol thing, which goes in effect on June 1st regardless.
Right, yep, correct. So,
But yes,
all right, so I will set this, I will do this. I'll try to get this done. I've got, I'm in the middle of final exams now and a lot of grading, and I have a couple big projects that I have to get done for my accrediting body for my program at school. But I will try to get this done and get this to us before the 20th to review. Both of you are welcome to edit that further, and we will discuss that on the 20th. So moving down, I guess the next thing was the COVID-19 update. It just seems like that information's a little redundant. We all kind of really know what's going on. I looked at the website today. It said we had 32 total cases in Adams. I know that the numbers are a little different depending on what you look at. David,
Yes.
how many active cases do we have now?
I couldn't tell you. I think it's single digits, but
Yeah, I thought it was 2.
well, it depends on whether you do the 14-day thing or not.
Right, right.
But yeah, as you
Okay.
see, I've been keeping, and Nancy's been good every day.
Yeah.
And
I think the big thing is that the numbers are going down, which is good.
Berkshire County is doing better
Yeah,
than the rest of the state. I mean, today's numbers really sucked for Massachusetts.
yeah,
We're not anywhere near that 2-week decline. But I would say the CTC still hasn't reached out to Berkshire County yet.
I got information from Nancy, because that was on our update. I put that on, and she she sent me, looking at it now, this was Monday. She said that the CTC went live at midnight on Monday.
Yeah,
I guess-
I know that. Well, whatever that means. They've had so many
Right.
problems.
All right, David, let me finish here. What she
Yeah,
said
okay.
was that they will pick up the cases, if the nurse does not, but she does not anticipate anything because she's keeping up with it now because the numbers are low.
Right.
So unless there's a big uptick in stuff coming, I think it's status quo. I don't think anything's gonna get involved. So,
Right. And then there's the CTC, like you said. So, we can rely on them. There is the CARES money, which has not come forth yet. Laura Kitros is thinking it'll be by the end of the week. I'm trying to keep track on that, and we'll pass it out. Jay hasn't gotten back to me. I did, and I don't know if he's working that through NVREPC, but I just want to make sure that we capture our amount, and we can use. There are public health dollars in the CARES Act, so that we can maintain. That's all I have to say on this. I will let you know whatever I hear.
okay. I do have two other things with this. There was a suggestion from Mark, and Mark has left the meeting, to have an emergency meeting to appoint the Adams Police Department, to assist with, enforcement of the face mask. I don't know where that stands.
I have had some private communication. I don't want to say too much, but this has not been a happy issue throughout the county.
Right.
And so Mark does have authority. And I don't want to go any further than that.
Yeah, I was gonna say that I don't think at this point, it's warranted to have a meeting to discuss that.
No.
Until we get further information, so, the next thing, did you get from AJ, was there any information on that MEMA stuff, or no? So, David, this is in regards to your letter that you sent us, to look at the language.
Yes.
AJ told me today that MEMA is actually providing funding for the testing for these congregate homes. So I don't know if you want to state that in the letter. But
I thought that was coming through National Guard, but.
No, this was new today. AJ told me today.
Oh,
But
cool.
what he was waiting on was MEMA's definition of a congregate home, and he was going to send that out today. And I'm asking the select board chair if she got that communication, because I did not get anything. So I would suggest holding off on sending that letter until we get more information.
I'm going to follow up with phone calls, and I've already started because I wanted people to have the recommendation.
Right.
And so yes, I will look at AJ's, and I can follow up with that. But Nancy, maybe Nancy just wrote to me, but she loved my letter. Go for it. And I mean, she's extremely happy because it makes her work a whole lot easier.
Yeah, I'm fine with that, but my point is that we might want to include information that there's funding for this, for these places from MEMA. That was the only point I was trying to make, so that could be included in the letter.
Yeah, so
that they could provide information, we could provide information on where they can get this.
So, yeah, I'll look, AJ will probably have that in his sit rep tonight, right?
Yeah, I don't know. That's what I was hoping he got that out, and, I didn't see any information on that, so.
I'll check MEMA and, it's his sit rep, well, it depends. Sometimes it comes out the next day, but, yeah, I'll check his next sit rep.
Okay, thank you. All right, anything else, on that?
Nope.
Okay. Just, I guess, for the good of the order, anything?
Oh, it's just, I drove by Specialty Minerals and just sort of mourned the pause in their process, because
Yeah,
we were supposed to have approval by months ago,
yeah,
and it's just, I'm just sad about business as usual, but that's it.
okay. Laura, anything?
No.
Okay, nothing from me. Review of mail, there's a couple of things here that Pam had left. One is the letter, about, the railways pesticides, and I know that she forwarded this through email, so that's nothing new. And then there's a booklet here from, open meeting law, stuff, so, you can connect with Pam if you want to get that. So I guess the next thing, the last thing is, scheduling our June meeting, if we want to get that scheduled. I know we're going to meet on the 20th. Do you want to schedule our June meeting?
Let me
No?
bang over there and
Laura, would it be helpful for you to schedule it now? Or do you
Yeah,
wanna wait
I probably, I don't know what my schedule is gonna be in June, so if we just schedule something, I can work around it.
till- Okay.
let's schedule it now, and then, of course, we'll see each other in 2 weeks, and we can
Okay,
adjust.
so the first Wednesday would be the 3rd, June 3rd.
Oh my calendar is free.
Laura, are you okay
Yeah.
with Wednesday? The 3rd?
Yeah, I am.
Okay. All right, so we'll do that. All right, I'll entertain a motion to adjourn.
Second.
I move. Second.
All
I
right,
approve.
all right, Laura?
Just say
roll
yes.
call vote, sorry.
Yes, sorry.
Okay, David?
Yes.
That's a yes for me. Okay, meeting adjourned. Thank you all.
Oh, please.
Okay. Get clean. Bye.
How do I hang that up?
So Jack
How
is
do you
still
hang it
there. Hey, Jack. How you been?
He's muted.
He's muted. I know.